1.
Good morning, everybody. Welcome to the July hearing of the Division of Oil and Gas and Mining Board. We're going to have our briefing session, followed by public comment. And we have 5 docket items today. We have 2 with a hearing examiner, 1 bond forfeiture, and 1 drilling unit reorientation, and then an issue on ownership, which I understand is going to be withdrawn. So once we get done with the briefing session, we'll go to agenda number 5 on the condition that this is simply a withdrawal, and then we'll proceed from there. So with that, we'll go ahead, Mr. Thomas.
Thank you, thank you, Commissioner. Pardon me, Chairman. I apologize. Lots of titles I can give you. Chairman Walker and members of the board, my name is Mick Thomas. I'm the director, as you know, of oil, gas, and mining. First item in my briefing, I would like to provide Mike Drake, who's with the Division of Water Rights, and Dana Dean, as you know, the Deputy Director over Mining, an update on the Emery County, specifically regarding water usage, and we're all in a pretty heavy drought this year statewide, sure. And that's impacted a lot of folks. So I'll kick it over to Dana and Mike. Thank you.
Thank you.
Okay. Yeah, nice to meet you all. My name is Mike Drake with Utah Division of Water Rights. My position is Deputy State Engineer, and so I work directly with our State Engineer, Teresa Wilhelmsen. And I'm here today just to give an update on one of the challenging situations we have this year related to drought, and that is the town of Emery's water emergency. So this is just one area that we're dealing with right now. There's at least one other town, and then a number of other water issues related to drought going on throughout the state. This year is extraordinarily bad. We started to see just how bad that was in this winter as we saw the abnormally warm temperatures and the little bit of snow that we got. Teresa and I were down in the Bryce Canyon area in February dealing with an issue, and it honestly felt like it was spring already in February. The creeks were already melting. There was no snow on the ground, and that was pretty much true many areas throughout the state. And so what we saw generally runoff this year was it came really early, and then it was really, really low. And for the most part, runoff peaked like 6 to 8 weeks prior to when it normally does, and the peaks were dramatically lower. We're running 6 to 8 weeks ahead of normal river flows across the state, pretty much. Just as a rough idea of where we are, Price is delivering at 25% of what 25% of what the rights are. Sand pitch is 10% of deliveries, and so these are really low numbers. Provo River, which usually has a good amount of water, is delivering at 50% of primary. Another example on the Weber, we don't often get into the 1860 priority water rights, but we're there now. That happens, somewhere around less than 10% of the time that we get down to 1860 priority water rights. So it's really, really bad out there. Irrigators are struggling, and we're starting to see even at places where, in the case of the town of Emery, where towns are starting to struggle as well. And so I'm here to talk about that primarily. And we were notified June 4th of the pending emergency that would occur. And just to kind of set some context to this, there was an initial public meeting that was held on the 18th of June. The town of Emery operates with water that's diverted out of Muddy Creek, and they divert under shares that they own in Muddy Creek Irrigation Company. Their ownership amounts to about 3% of the company total shares that are outstanding, which is a pretty small amount. And this year, that amounts to a tiny amount of water. And so they called emergency meetings and summoned all the help that they could. They've got great people pushing behind this. and making sure that people don't forget about their situation. So they're definitely facing issues with limited water coming out of Muddy Creek, and that's their sole source of supply. They do have a backup well. However, groundwater in this area is generally poor in quality, and so they've turned it on in the past, but it's really not usable. And I'll get into that in a little bit. But some other things that they also have rights, or through Muddy Creek Irrigation Company, they also have there's a high elevation storage reservoirs. And so there's a few of those, and those are draining quickly, and so there's not much help that can come from those. One of them has actually been taken out of use because it was having some seepage problems. I'm trying to remember how long ago. It's been a number of decades since that reservoir was taken out of use. And they, like I say, they do have a backup well. So let me get into some of what our division has done, the Division of Water Rights. Following that initial public meeting on the 18th, they requested a well renovation application to try and get that well up and running again. And we granted that quickly, and they then tried to turn the pump on, and it promptly broke on them. And so they need to source a new well pump. But even at that, they still have the water quality issues they need to deal with down there. The other thing that our division did is we granted a temporary change application, and this is to facilitate what might become a water hauling operation. And so they've been authorized to divert water from the Quichapa and from Ivy Creek, if need be, to bring water to their water system. Most recently, an update meeting was held on July 16th. Their primary focus at this point is funding. These things are very expensive, whether it's retrofitting the well or running a pipeline from Quichapa or whatever it might be. These are, the town doesn't have the funds for this. What they reported also in that meeting is they believe they've been able to make some agreements with some local farmers to keep water flowing to the town for municipal purposes. They think they're going to be able to squeak by until winter, but they're really concerned that Muddy Creek is going to freeze hard this winter with such little flow, and that will completely cut them off from all water from Muddy Creek. And since there's no reservoirs to draw from, that'll be really challenging for them. So let's see if there was anything else I wanted to add. They're evaluating a number of options I mentioned the pipeline. They're looking at renovating the well. They're looking at potentially installing treatment that could work with the water from the well. They're looking at retrofitting the reservoirs. They're looking at potentially replacing those reservoirs with a low elevation reservoir. And so that's kind of where we stand right now. They're evaluating options and really generally looking for funding.
Thanks, Mike. You may be wondering why this is a subject for the Board of Oil, Gas, and Mining. The Sufco mine and the Emery Deep mine are both close to the town of Emery. On June 26th, we actually got a citizen's complaint from two citizens who want to remain anonymous, alleging that the Sufco mine had damaged the town of Emery because they discharge water that they think should be going into Muddy Creek into Quichapa Creek. As you heard, getting water from Quichapa is harder for the town. They would have to truck it instead of using their existing pipelines and things like that. But the division reviewed the complaint and found that that situation, was settled by court cases in the 1930s. We do not tell mines where to discharge water when they encounter it underground. They're allowed to do whatever is safest and most expedient for their operation. That's based on, again, court case precedents that go back to silver mining in Park City in the early 1900s. The other things that were looked at were some springs and other things near the mine and in between the mine and the town, and those were found to be flowing at rates that were consistent with seasonal variation. So we did not find anything beyond the drought that is affecting the town. When we sent our response back to the citizens, they said that they would have more questions, so we're expecting that this will continue. We've also been asked, could people drill into the mine and get water out? So we're ready to answer those questions. I wouldn't suggest it while the mine is active. They have talked about, BYU actually did a study with the BLM a few years ago looking at when the mine is mined out. Is that something that could happen? That would be a water rights question. I think at that point, the Division of Oil, Gas, and Mining would no longer regulate a closed down mine. So we're looking at what's happening. We're keeping an eye on the mine, and we're participating in these meetings and seeing if there's any way that the division can be helpful. But at this time, we did not find that the Sufco mine was affecting anything, and we do not think the Emery mine is either. We have several monitoring wells close to that Emery mine, and we have several spring, stream, and well locations for the Sufco mine.
Okay. Good. Board, do we have any questions? Looking over here to you mining guys. So. No?
Not related to this, but yeah, other things on the hydrology. Well, I assume like Emery Deep, their wells there are.
Your mic is muted. We can't hear you.
In the Manco Shale, that's why the
Yes.
water quality is so bad.
Yes.
Mm.
So.
Okay. Anything else? Matt, is there anybody online that wants to make a comment on this?
There's no public comment online.
Okay. All right. Okay.
Oh, excuse me. Sorry, Mr. Chair. I just wanted to, I forgot to say that that citizen's complaint and our response is on our website with the names redacted if anyone wants to look more in depth into that.
Okay. Okay. Go ahead, Jordan.
So is there any possibility of utilizing that water by the city that's coming out of the mine?
I believe, in a in a indirect way, yeah, I think they're looking at that. That would be why they're looking at diverting water from Quichapa, is they would be able to access some of that the drainage water that's otherwise just flowing downstream, and so they're looking at it certainly for this temporary application in the event they need to haul water because it's low elevation and they can get their hands on it pretty easily. But then they're also looking at it as a potential, if they were to put a pump station in and a pipeline and run that up to their treatment facility in town, that's certainly a possibility.
So they're looking at the possibility of taking it from the mine mouth over to their own treatment facility.
Well, I don't.
Not the mine mouth,
is that what
from
you're saying?
Quichapa Creek. So Muddy Creek flows down close to Emery. Quichapa flows down into the same valley, but it's further away from town. And Quichapa is where the mine is discharging. And as Mike said, there's a temporary change application so they can take that water instead of Muddy Creek because that's where it's going. But getting it right now, they don't have infrastructure in place to just pipe it to town, so they would have to truck in the short term. And I don't know if they're looking into long-term piping to their water treatment plant, but that would be the best thing for them to do.
They're evaluating a number of options right now, and there was some state and federal representation on some of these meetings, and they're saying you really need to pick one. So make up your mind and decide what you think is going to work best, and then come to us with that. That's kind of what the current direction from state and federal leadership is.
They're looking for any funding they can get to help them with these challenges.
Okay.
And the Sufco water is much better.
Yeah. Yes, it's good quality.
Okay. And it all ends up in Colorado eventually, right?
Yeah,
Yes.
this entire area is the Colorado River Basin, so correct.
Okay. Board
And-
members, go ahead.
Sorry, and so let's say they were going to do a long-term, pipeline from Quichpa to get it there. That is, they can't file on that. That's just there as long as the mine is discharging. Is that correct? Like they couldn't, it's unappropriated water and is it fully adjudicated?
Yeah, this area is adjudicated. I would foresee that they would file a change application on their existing water rights, whether that's Muddy Creek irrigation shares, share-based water, or with their underground water rights, which the temporary change application was filed on their underground rights
That's what I would-
to permit kind of a 1 year, a short-term diversion of water. So it's not new water. It's just a different place to take the water. Basically, is what was authorized there. And I imagine the same would happen if they were to identify a permanent solution from Quichpa.
Okay. Anything else? Well, Mike and Dana, I really encourage you guys to continue to work together on these sorts of things. We got tens of thousands of barrels of water in the Uintah Basin. None of it's much good for you, but technology in 50 years may be different. But continue to work together on those sorts of things. All right. Anything else?
No, thank you.
Okay, thank you very much.
No, thank you.
Okay.
Members of the board, Chairman, thank you for that, allowing that topic. Again, 90% of what I think the board does a lot of times is oil and gas, but anytime the industry has the opportunity to collaborate regarding water rights, and why we talk a lot about mineral resources here, water is pretty much top in Utah, second driest state. I'll always take this opportunity to share the benefits of the produced water recycling statute from 2024 that has taken significant amount of fresh water that was being used to complete wells, and as you alluded to, Chairman, is now able to be used in other areas. So we appreciate the board and the industry's support in holistically helping us to manage a very finite resource here in the state. There's no actions I think that the board will need to take out of this entire thing. It's an informational issue, but if something comes up that we don't foresee, we'll come back on that. Thank you again for that. The second item, some new rulemaking topics. We've asked Natasha Baloff to come up and speak to that. So I'll kick it over to Natasha. Thank you.
Thank you. I'm Natasha Baloff. I'm the Legislative and Planning Coordinator for the division. And I have a couple rulemaking recommendations for the board to evaluate, hopefully give your blessing on. Now that we have completed bonding rulemaking, that was a really big lift for our staff. And now that that has an effective date, right now we're recommending pushing through a handful of smaller rulemakings. We essentially have the language ready to go. Those include clarifications to the recycle facility reporting requirements, some gas reporting requirements as well. We have plugging and abandonment, some monument language that we would like to add in, some surface disturbance language, and some clarifications to our administrative penalty rule. All of these we think would have industry support. We don't think that there's going to be too many stakeholder meetings where we're going back and forth. So hopefully we can bring those to you in the coming months. And then in the background, internally, we'll start working on horizontal well drilling and some clarification to our application for permit to drill language. This should help our field staff more effectively do their job. So I'm open to any feedback from the board, any blessings that you want to give on this route forward, but I'm open for questions if you have any.
I guess to start with, you got 4 primary topics on those minor adjustments. Maybe we actually have 4 hearings left in the year. So maybe
Oh, yeah.
shouldn't we try to maybe do 1 or 2 per month to try to get that taken care of.
Yeah, we can definitely do that.
Yeah, and the horizontal wells and the APD might be a little bit bigger lift, so as we work through things, maybe get those towards the end of, if we can take at least a look at those
Yeah.
before the December hearing, or for the December hearing.
Yeah, I'll see if we have language ready to go for the bigger rulemakings. I know that we have some language around horizontal well drilling. As far as I'm aware, we don't have anything written down for the application for permit to drill, but we do have ideas that we can put on paper. And I did fail to mention that we will have a mineral rulemaking coming forward, and this will address exploration permits. We would like that to not have an expiration date on it or like a renewal every year. So those will be some smaller updates that we should be bringing to you, I think, in September, either September or October.
Okay. And so the short ones, that'll actually be formal rulemakings, right? And the other 3, you're talking about, we could start the informal process.
Yeah, the
Start
bigger,
talking with industry and that sort of thing.
yeah. The smaller ones will still reach out to stakeholders beforehand and make sure they agree with the language. We don't want to start formal rulemaking if there needs to be changes. So we will do that legwork beforehand before bringing it to you and beginning the formal process. With the horizontal well drilling, I think that there will be some back and forth, maybe a couple months for an informal process.
Okay. Okay. Go ahead, Steve.
Natasha, any of this rulemaking related to the past legislative session, any statutes that have required this, or is this basically housekeeping?
A lot of these are housekeeping. The mineral one does have some statutory language that we've been updating, and at some point, I'm not exactly sure when, but we will have an expedited permit process that we bring before you, and that one is based in or originated from statute. So that one will apply to both our mining side and our oil and gas side.
And I guess also with the lengthening of the horizontal wells, that's going to add a new dimension, to the abandonment.
Yeah.
Interesting.
Okay. Any other questions by the board? Okay. Thank you.
Okay, thank you.
Go ahead.
Thank you, Natasha. Moving on to number 3, not much, as you all know, as Natasha just spoke to, the oil and gas bonding rule was quite a lift over multiple years and had a lot of different team members, stakeholders. Good job to the board. Thank you for helping that get through. That is effective as of, I think, July 1st, but it is in effect now. The division, the only update I have there is the division is working to finalize our bonding calculator so that stakeholders can go in and accurately find out what their bond is. We're working internally and also with a contractor on that to get that finalized. We anticipate that'll be ready by September. If not, then we may go manual, but it's moving ahead of schedule right now, so we should be okay. And that's more of a notice for the stakeholders. I want you to know that. Before I move on to 4, are there any? Don't let a horse lie. If you have any questions regarding the oil and gas bond, now's a good time to. Maybe not a good time to mention it, but you're welcome to.
I think we're ready to move on.
Thank you. Thank you on that. Number 4, the state, as of the governor's office took the lead on this, has moved toward a unified logo. This has been several months in the works. That logo is now live and available on the employee portal. The first indications you'll see of it is in our signature field. We've all been asked to convert our signature, our email signature, over to the new logo. We are going to move forward with branding on some safety equipment first, hard hats, vest, apparel, and that's moving forward with all agencies throughout the state and all divisions. As you look around the room, we all have the old logo still on the wall behind you and stuff, and I'm sure that'll be changed eventually. It's not a priority right now. It's functioning really well. But that logo is available. And if any of you use your OGM email to email out, or anything you send out professionally, please work with Matt Morgan, who you all know, to make sure that all of our signatures are unified there. But it's interesting how much of a lift that was, right? You'd think a new logo was relatively straightforward. Boy, it was not. It was several months and a significant amount of energy to collaborate and get everything together there. So that's just an update. I don't know if there are any questions, but you're happy to ask any questions on that. And if I can't answer it, I'll have Matt chime in.
Okay.
Thank you. Something we are excited about, again, this year, we will be participating in the Uintah Energy Summit in Vernal on September 23rd. We are going to hold a board meeting live on site there. Patty and I are helping, actually Patty's doing almost all of it, let's say, to coordinate and make sure that you all have rooms if needed to participate in that. Matt Morgan is working very well to make sure everything, all the data and the streaming is ready. And just a heads up, I think many of you are looking forward to the Energy Summit. Some of you won't be able to go, but many of you will be, and we're happy to continue to coordinate that with you. Any questions you have about that, reach out to Patty or Matt or me, and we'll make sure that everybody is live and there, and we can move forward with the remote meeting as we have in the past couple of years.
So that suffices to be warning to everybody in the public that we're going to have our hearing in Vernal on
That's right.
September 23rd. So plan that way.
Yeah, thank you. I do believe, and I'm a little bit out of my lane on this, I believe that council still has to be in person, but there is a remote option for almost anybody else in case they want to, and just let us know in advance. I'll ask board council if that matches. I think it does historically. All right, thank you. Under other items, just some updates on some ongoing things. First, the first meeting of the Critical Mineral Council was last month. As a co-chair, I made a motion to interview operators, specifically mine operators, regarding what sort of features they would like to get out of the council, including what sort of facilities and support they would get out of a mine center, which the council is administering. I quickly delegated that to Dana Dean. I love doing that as a director, and said, okay, Dana's going to do it. She was not in the meeting, which is always super fun when she finds out later. But as typical, Dana jumped on it and is going to begin evaluating operators in the state to see what information and what resources the council can best provide. The Critical Mineral Council is there to support critical mineral development, not only mining, but also processing in the state of Utah, and wants to help and has the backing and the resources to help. So we want to make sure that those resources are best allocated, and who better to share than the folks who are actually needing them. So there's a heads up there. Yesterday morning, we had the Natural Resources Council at the Capitol, and that is a usually quarterly meeting, although it's been postponed so that we have another one next month. But it's a quarterly meeting with all of the federal and state agencies to come together and discuss resource development, management. There was a lot of talk about fire, a lot of talk about data centers, which thankfully the division is not involved in. That's something we're really happy to not be engaged in because that's a hot topic. But also we talked about, specifically regarding for the board and the division, ways that we're collaborating. One of those is a cooperative agreement for permit streamlining for oil, gas permits, and also mining permits. The BLM was there. They are readily engaged as we move forward with that. You know, Commissioner Selma understands that things move painfully slow sometimes. You know, I'd hoped it was all going to be fixed a year ago. Boy, here we are, right? The division is...
We were there 15 years ago.
I know, right? And I'm going to be talking about it probably for a long time. We have brought in a DNR, the Public Lands and Policy Coordinating Office, to help here with this, or to help us on that. Specifically, the ability to reach out directly to DC and our federal representatives and senators to help move the ball on that. The BLM, they're in a good place, but they're on their third acting director. and it's hard, understandably, to get decisions in that role. Nothing against the acting directors, but you understand, right? It's difficult to get traction on those things. So we're hoping we can provide some support to them by coordinating with our DC constituents. So there's an update there. We are also moving forward with an initial assessment from a software contractor to build out what a streamlined large mine permit would look like for the state. That Dana Dean and her team are really leading out on that. We want to make and enable the large mine permits to be faster, significantly faster. Obviously, the cooperative agreement segues into that because the biggest delay for a large mine in the state or really in the West is our federal partners. They do not track how long it takes themselves to complete a large mine permit. There's no measurable there. We have to get that from operators, and that's somewhat telling, right? Now, for the state of Utah, we're much quicker. We do pretty well. I think it's sub 2 years, and Dana may correct me on that, but we're doing pretty well on the large mine permit there if everything is completed. But we're working on that. That's one of the initiatives that was given to the division beginning this fiscal year 27 and out of the legislature. Also, on the oil and gas side, we understand that our data system is functional now, but we want to make it better. A much more user-friendly system where information is readily available. And I think Jen and her team, Deputy Director Middleton and her team are evaluating options there and have a lot of great ideas. So I think there'll be more to come to that. And finally, thank you, Commissioner Moon invited me, I guess about 3 weeks ago to speak with the Royalty Owners Association. That was an enlightening topic and meeting. I really appreciated the time that you all provided. I took that information back to our team, and we are building out a much more robust public-facing sort of information center, body of information for royalty owners so that they know what the board and the division can and can't do. But I look forward to those ongoing collaborations with the royalty owners. They're a big part of what we do here in the state, and I appreciated their time and the input. That's all I have under other topics. Are there any questions before we move on?
Yes, Director Thomas, I see on social media that there is a public meeting that you'll be speaking at on August 4th or 5th. Is that something that's open to the public, or?
Are you talking about the Monticello next week?
It's August 4th and 5th.
The One Utah Summit. Excuse me. Thank you, Patty.
Could you tell me about
My calendar is, I have people who help me a ton. Every year, this happened yes, it is open to the public. The One Utah Summit is a 2 to 3 day event down in Cedar City where many of the state agencies come together with business and talk about how to grow business and innovation in Utah. There's a number of topics that come up. Water use will be there. We'll be talking about critical mineral development, specifically for the division. Energy holistically. I'm sure there's going to be discussions about the nuclear reactor and the nuclear power growth in the state. The Office of Energy Development has a big play there, as does the Governor's Office of Economic Development. I will be main stage hosting a critical mineral discussion panel for probably about 15 minutes on the second day. I think portions of it are streamed, but it's a big event. There's going to be several hundred, if not a few thousand people there converging to the university down in Cedar City. And everything is YouTubed and archived. So if you can't make it down, you can watch and follow up on it after that. But thank you, Commissioner. And thank you, Patty. I appreciate it.
Do you know if there's a fee to watch the online?
I don't think there's a fee to watch online.
Okay, thanks.
Thank you.
So if you guys want to watch it, get a hold of Patty and she'll give you the link.
Or probably Matt Morgan as
Matt.
well. Patty or Matt can figure it out. Okay. Well, with that, next month we're going to be here again. Again, we mentioned we have the September 23rd meeting, but next month we'll be here on August 26th. We have a handful of dockets already ready for that meeting. There may be additional dockets that come on. And that's all I have. I think you can open to public comment if you want, or whatever you think, Chair.
Okay. Anybody have questions for Director Thomas? I'll ask one question, see if you have any info. On the blowout that happened about 2 months ago, do we have any information on the root cause analysis at this point in time?
The division does not, and is not actively tracking that. Again, we have water rights here, but that's not his purview. I think he was talking more about the other sources, so I don't at this time, Chairman.
Okay. Be helpful to us if you had some knowledge on what's going on there. Okay. All right.
Thank you.
Thank you. All right. So at this point in time, this is where we have the opportunity for public comment. Is there anybody in this room that feels like they want to make a public comment? Seeing none. Matt, do we have anybody online that wants to make a public comment?
We do not have anybody online for public comment.
Okay. So I think we will go ahead and proceed then to the formal part of the hearing. And we will start with docket number 5, which is Uintah Brine Corporation. Now, typically, once the agenda has been set, we stay with the agenda. Today, since this is going to be a simple procedure to withdraw the request for agency action, we'll go ahead and interrupt our normal procedure. But just keep in mind that a request to change the docket, the day of the docket, is typically going to be denied. So we'll go ahead and proceed. All right? So let's take appearances.
Good morning. I'm Justin Rammel for Uintah Brine Corporation.
Okay.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay. Do you want to read this one in? Yes. Okay. Number 5 is docket number 2026-026, cause number 379-05, in the matter of request for agency action of Uintah Brine Corporation, LLC, for an order vesting operatorship in the Big Indian Unit 1, API number 43-037-16219, and the Lisbon B912 well, API 43-037-15769, Uintah Oil and Gas Wells. This matter was continued from June 24th, 2026 board hearing.
Thank you. We appreciate the opportunity at the last hearing to present evidence and witness testimony in regard to the request. Since that time, we've worked with the division, and Uintah Brine Corporation's accomplished their goal. And Mr. Haynes may wish to make a statement in that regard, but in light of what's transpired the past month, the request is moot, and we would move to withdraw it.
Mr. Haynes?
Yeah. So since we had the hearing last month, the petitioner was able to provide the division with documentation related to their rights to enter the subject wells. After review, the division is satisfied with the documentation that was provided and believes that Uintah Brine Corporation has the right to enter the wells for purposes of processing their change of operator form. The division is currently processing the change of operator form and awaiting any objections from the BLM due to these wells being federal wells. And so with that in mind, I agree with the petitioner that this issue is moot.
Okay. So there isn't really any action required of the board at this point in time other than to dismiss dismiss this docket number. Is that right?
Yeah.
Is that how you see it, Mr. Haynes?
Would you like an order of dismissal that indicates the division's response?
Probably.
Okay.
Okay.
So yeah, we can make a motion to dismiss this without prejudice and have an order that indicates why it was dismissed.
Okay. Would someone like to make that motion?
I move that we approve this agency request to withdraw this RAA and draft an order according to what you just did.
Okay. Is there a second?
Second.
Motion's been made and seconded to withdraw this request for agency action. All those in favor say aye.
Aye.
Any opposed, say nay. Any abstain? No? Seeing none, it's so withdrawn without prejudice. Okay?
Thank you very much. We appreciate that.
Just one point, though, I do want to make. I will be traveling from August 2nd until about the 12th. So any orders that are requiring my signature, please have those to the board secretary by August 1st, so I can take care of that before I leave.
Okay, thank you.
Okay? Thank you very
Noted.
much.
Thank you.
Thank you.
Thank you, everybody.
Thank you. All right. So we will go on now to agenda item number 1. Okay. And there are no exhibits. Okay, good. Okay. Okay. Okay, good. Agenda item number 1 is docket number 2026-033, cause number 132-90, in the matter of the request for agency action of WEM Operating LLC for an order pooling all interests, including the compulsory pooling of all interests of non-consenting and unknown owners within a 2,567.545 acre or substantially equivalent overlapping drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River and Wasatch Formation comprised of sections 5, 6, 7, and 8, Township 4 South, Range 4 West, USM, Duchesne County, Utah. Let's take appearances.
Brent Chicken, Step 2 on Johnson, PLLC, Denver, Colorado, on behalf of applicant WEM Operating LLC.
Okay, thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Great. Okay. Nico?
Nico Micheletti, Assistant Attorney General on behalf of Mr. John Rogers.
Okay, thank you. Okay, and before we get started, I'd like to disclose first off that my wife and sister-in-law are working on a probate issue with WEM, which is in nearby acreage, but not this acreage. So I just want everybody to be aware of that. I don't see a reason to recuse myself at this point in time. Any objections?
None.
Division
No objections.
and council? Okay. All right, so let's go ahead and proceed then.
Thank you, Chairman Walker and members of the board. As indicated, my name is John Rogers, and I'm an environmental manager with the Division of Oil, Gas, and Mining. And I act as the hearing examiner in this proceeding as directed by this board, as described by Chairman Walker. The proceeding was held in an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, July 15th, 2026. At the beginning of the hearing, Mr. Craig Johnson, a member of the public who indicated that he had a family interest in the name of Ben Holly, of which he claimed to be related to along with several other family members who were not present at the hearing. He was at the hearing to better understand the process. It was concluded that there was a probate issue, and representatives from WEM agreed to meet with him and discuss the situation. WEM and Mr. Johnson had a brief conversation during the hearing and agreed to discuss the situation after. No member of the public was online. Mr. Chicken, did you have that conversation, and do you want to clarify what was happening or what happened there?
I can, I'm going to turn it actually over to Mr. Yang, who's the land manager,
Okay.
because I believe he just talked to him, actually. He was here this morning, and we were talking to him as well. So I don't know if you need to have him sworn in for this, but I would direct that because he's got boots on the ground with that gentleman.
Okay, can you swear him in? Okay. Yeah, okay, so let's swear Mr. Yang in, please.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay, go ahead and proceed.
Okay, could you just identify what the issue was and how it was clarified and the results of it?
Sure. Mr. Craig Johnson was representing his family, who are part of the Hawley family. He brought in the concern where they have there are mineral interest under several deceased members of the family, which are record title owners as WEM Operating has identified. And his primary concern was how would they still be able to get paid royalties even if they're considered as non-consenting parties through this forced pooling. We explained the process of forced pooling to him and explained that even with this order going through, he will, all of the record title owners will be entitled to a royalty under the acreage weighted average royalty percentage through the compulsory pooling, and that if we were to take leases and if the probate requirements are all done, we would still recognize those leases with the heirs. I explained to him that WEM's policy has always been landowner focused, and we have always been active at conversing with heirs of deceased mineral owners, doing protective leases and helping them to understand the process that they must go through with legal probate and so on, and that, you know, we have informed him that we're very happy to meet with him and his family and discuss in person on what their next step would be. And he was satisfied with that invitation, and especially with the comment that that is about royalty. He understood that even if the compulsory pooling would go through, his family would still are entitled to royalty payments from the production of oil and gas.
Okay. Thank you.
Yeah, occasionally we will have members of the public or people that think they're involved with this or relatives, and I think it's always good to have the opportunity at the time of the hearing to have the operator and those people indicate what needs to be done. And it's always something different, but it's a good chance to go forward. As we get the term force pooling, it always strikes kind of a fear into some people, so I think they better understand it. So appreciate you working with them and talking it over.
Thank you.
Yeah, and I've had a front row seat to some of this recently, so I'm glad to hear it.
Okay. Okay, during the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of WEM Operating. Mr. Alexander Yang, who we just heard from, a land manager, and Mr. Trevor Fields, a reservoir engineer, both from WEM Operating. Both declarations were reviewed by the division and me prior to the hearing and accepted as evidence. The attorneys just introduced were present at the hearing and represented the representative clients. Both WEM's witnesses were accepted by the division and me as expert witnesses in the field of work on this matter. Both witnesses presented live testimony at the hearing. The division filed a response and notice of non-opposition to the request for agency action dated July 8th, 2026. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of WEM. Questions were introduced concerning notification, risk penalty, heirship, and all issues were answered at the hearing. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. WEM provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those owners that failed to participate timely should therefore be considered non-consenting parties and compulsory pooled. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. A 100% risk compensation awarded to applicable surface equipment beyond the wellhead connection, and a 300% risk compensation award applicable to drilling and completion costs. The 100%, 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of these wells. Therefore, I recommend the 100 and 300% non-consent penalty be imposed as requested. WEM has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest, WEM's working interest is approximately 56.89%. Non-operating working interest is 40.14%, and the non-consenting compulsory pulled interest is 2.97%. The average weighted fee landowner royalty was approximately 18.4%. The estimated plugging and abandonment cost is $100,000. WEM's counsel, Mr. Brent Chicken, prepared the proposed finding of facts, conclusion of law, and order granting its request for agency action. The division, Nico Micheletti, and I reviewed the proposed order. I then executed the proposed order and filed it with the board's legal secretary. It should now be ready for the board's review and execution. I'll take any questions at this time if you have any.
Board members, any questions?
Just a question.
Yeah.
So that's a pretty large non-operating working position. Who is that? Who, multiple companies or?
Thank you. One of our majority working interest owner industry partner is Berry. Well,
Okay.
used to be Berry Corporation.
Okay.
Yep. Now they're sold to the new company.
Any other questions?
Okay.
WEM, do you have anything to offer more? Or?
No further comment.
Okay, great.
Okay. Division, any comments?
No additional comments.
Okay.
I have one quick question. I was just looking at the notice of opportunity to participate, and it does have the what was it called here? Oh, the decimal interest. 0.0. Well, I'm looking at just one particular non-lease party. What are your thoughts about putting the net acres on that? Because for a mineral owner, that's so much more helpful than a decimal interest, because then you need to know how to calculate that. Just wondering your thoughts about that.
I think that's definitely something that we can consider for our future notices.
Okay, just a thought. So, okay.
Okay. Any board have anything else? Entertain a motion?
I'll make a motion that we approve the request for agency action for compulsory pooling as presented.
A second? Second. Okay, motion's been made and seconded to approve the request for agency action. All those in favor say aye.
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 Any opposed, say nay. Any abstain? Okay, motion carries. And again, it's you doing the order, right? Or do you, or we already got it?
There's 3 copies of each.
Yes, we have the order. The division's reviewed it, I've reviewed it, and we've approved it. We'll get it to you as soon as we can.
Okay, very good. Because as again, I'm going to be gone for a while. All right.
Yep.
Okay.
So Nico has 3 copies of the order for the chair to sign, subject to crossing out Ms. Garrison's name
Okay.
on them, and we can. The other
We can do
he's
that
got-
during a break then.
right after the next one. Those are the same exact orders, and they're ready for signature.
Okay. Okay. All right. So we'll go on to item number 2. Let me find it. There it is. Okay, good. Okay, docket item number 2 is docket number 2026-34, cause number 132-91, in the matter of request for agency action of WEM Operating LLC for an order pooling all interests, including the compulsory pooling of all interests and non-consenting and unknown owners within a 1,294.645 acre or substantially equivalent overlapping drilling unit established for the production of oil, gas, and associated hydrocarbons for the Lower Green River and Wasatch formations, comprised of sections 5 and 6, Township 4 South, Range 4 West, USM, Duchesne County, Utah. Take appearances.
Brent Chicken, Steptoe and Johnson PLLC, Denver, Colorado, on behalf of applicant WEM Operating LLC.
Okay, thank you, Mr. Chicken.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay.
Assistant Attorney General Nico Micheletti on behalf of Hearing Examiner Mr. John Rogers.
Okay, thank you. Go ahead, Mr. Rogers.
Okay, thank you, Chairman Walker and members of the board. Again, my name is John Rogers, Environmental Manager with the Division of Oil, Gas, and Mining. I acted as the hearing examiner in this proceeding as directed by this board for the matter just described by Chairman Walker. The proceeding was held in an anchor position at Department of Natural Resource Building in Salt Lake City, Utah on Wednesday, July 15th, 2026. There were no members of the public present in person or online. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of WEM Operating. Mr. Alexander Yang, a land manager, and Mr. Trevor Fields, a reservoir engineer, both from WEM Operating. Both declarations were reviewed by the division and me prior to the hearing and accepted as evidence. The attorneys just introduced were present at the hearing and represented their clients. Both of WEM's witnesses were accepted by the division and me as expert witnesses in their field of work in this matter. Both witnesses presented live testimony at the hearing. The division filed a response of notice of non-opposition to the request for agency action dated July 8th, 2026. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on WEM's behalf. Questions were introduced concerning notification, the risk penalty, heirship, and all issues were answered in the hearing. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and having heard live testimony presented at the hearing, I found and recommended the following. WEM provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners that failed to participate timely should therefore be considered non-consenting parties and compulsory pooled. The proposed joint JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings with the parties. 100% risk compensation awarded to surface equipment beyond the wellhead connection, and 300% risk compensation award applicable to drilling and completion costs. The 300% non-consent penalty is fair and justified given the economic conditions and geological conditions present. Therefore, I recommend 100 and 300% non-consent penalty be imposed as requested. WEM has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. For your interest, WEM's working interest is 74.0%, non-operating working interest is 20.11%, and the non-consenting compulsory pooled interest was 5.89. Again, those are just approximate numbers. The average weighted fee landowner royalty interest is approximately 18.40%. The estimated flooding cost was $100,000. WEM's counsel, Mr. Brent Chicken, prepared the proposed finding of fact, conclusions of law, and order granting its request for agency action. Division, Nico Micheletti, and I reviewed and approved the proposed order. I then executed the proposed order, and it will be filed with board legal assistant. It should now be ready for the board's review and execution. I'll take any questions at this time.
Board, any questions? Okay, and I should, again, disclose that, same thing, my wife and sister-in-law have a probate issue that they're dealing with WEM, and just need to make sure everybody's okay with that. And it's not this acreage.
No objection.
Okay. Andrew?
Yeah, no objection from the
Okay,
division.
Nico?
No objection.
Okay, thank you. Okay. Board, any questions of Mr. Rogers? Okay. Seeing none.
Before we get into a motion, I would like to point out to the board that Mr. John Rogers will be retiring here very shortly from 25 years of state service and 16 years within the Division of Oil, Gas, and Mining. So I just wanted to point that out and congratulate him in his years of service. And hopefully we can get him back on a John Baza situation, you know, where he just keeps coming back over and over year after year. But anyways, just wanted to point that out for you guys.
Thank you, Nico.
Almost
Just wanna say
irreplaceable.
It's been a privilege working with this board over the years. I know it's changed over time, but it's always educational and have been supportive, and appreciate that. Some of us go way back to the beginning, and even Mr. Church there, I worked with him over in Denver years ago, many years ago. And so it's a good opportunity here, and I'll be hard to leave, but it's time to move on.
So when is your last hearing, Mr. Rogers?
Today.
Today is your last hearing.
Yeah.
Mr. Rogers, I wanted to acknowledge your work of service when I was at the Bureau of Land Management, and I think the director mentioned the cooperative agreement that we had been working on back when, and I really appreciated all the work that you did to actually initiate all of that work that we started doing, and your vision for really trying to facilitate industry's ability to access the resources responsibly, and your dedication to public service. So I just want to thank you for that and acknowledge the great work that you did, at least with me.
Thank you. Well, it doesn't seem that long ago, but time marches on, doesn't it?
Wow. Well, thank you, Nico, for bringing that to our attention. Let's get back to the request for agency action. Any other questions? Okay, comments?
No further comments other than to note that this matter is a 1280 inside of the 2560 that the board just approved. So the prior was a section line. This is inside of the 1280.
Okay, thank you. Mr. Haynes?
No additional comments from the division.
Okay.
Quick question. So I noticed one of the unleased owners was Elk Range Resources, and that's a mineral buyer. Why would they not participate? Why would they be force pooled? It just doesn't seem like a good investment. But
that is a good question, Mr. Moon. I can't really speak on their behalf of their, choice of not choose to.
but they did engage. They did engage with you and decided to go non-consent.
Correct. We've sent out notices, and in the industry we talk, right? I've been speaking with their landmen before on other issues, and for this one they were notified, and we haven't heard back from them. After several notifications. It's hard for me to, to kind of say what their reason might be.
Okay.
But at least I could comment on that. Even if they are a non-consenting party, they would still come back after 300% as a working interest owner, and sometimes that's more beneficial for certain people than actually participating and take on the risk.
Thank you.
Okay, thank you. Any other comments or questions? I'll entertain a motion.
I would move that we approve this request, or this the hearing examiner's final recommendation.
Second.
Okay. It has been moved and seconded that we approve this request for agency action as introduced by Mr. Rogers. All those in favor say aye. Aye.
Aye.
Any opposed, say nay. Any abstain? Okay, Mr. Rogers, you got by one last time with a unanimous approval of the board. Motion's carried. Thank you. Okay, next item is agenda item number 3 is a bonding issue. So we'll go ahead and do this one, and then maybe we'll take a short break after agenda item number 3. Okay. Okay, I'll read this into the record and we'll get going. Okay, agenda item number 3 is docket number 2026-032, cause number S0210046. In the matter of the notice of agency action for bond forfeiture and reclamation at the Desert Mound Waste Removal Project, operated by Sonev Construction, LLC, located in Iron County, Utah. Okay, we'll take appearances for council.
Thank you, Chairman Walker. Assistant Attorney General Gary White here on behalf of the Division of Oil, Gas, and Mining. I'm also here with O'Hara Fellow Josie Lipton. She is appearing before the board today pursuant to Supreme Court Rules of Professional Practice 4-807. This is a rule that allows a law student to practice during their third year. Ms. Lipton has taken the required evidentiary courses, and she's received client consent to present today. So she'll be doing the bulk of our presentation.
Okay.
We also have division expert Brian Reyna online, and we expect that he'll be offering testimony, so perhaps we should begin with him being sworn in before Ms. Lipton's presentation.
Okay.
If you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
And it appears that there are no counsel for the respondent.
Yes, no one has appeared or responded in this matter.
Okay. All right. Go ahead, Ms. Lipton, proceed.
Thank you, Chairman Walker and members of the board. We're here today on a matter seeking bond forfeiture and an order for reclamation in the Desert Mound Waste Removal Project in Iron County, Utah. On screen is a photo of the mine site. We also have a map and an aerial view for the board's reference. I'll ask Mr. Reyna to provide a little more context as to the location and the current state of the mine.
The operation is on the Desert Mounds, Utah, kind of an iron mining area. It is primarily a waste rock dump that is being repurposed into construction aggregates. It is approximately 15 miles west of Cedar City, Utah.
Getting into some background facts, the mine site is located on BLM lands in Iron County and was permitted by the division in 2021. The operator is a corporation called Sonev Construction, LLC, and that entity filed for bankruptcy in 2022. It's led by an individual named Keith Gilbert. The purpose of the operation was to remove old waste rock from a dump site of a pre-law mine and process it for construction uses. Currently, the division holds a surety bond of $15,700 with QBE Insurance Corporation. On top of that, the BLM has its own performance bond of $2,100. Moving into a more general timeline, in terms of Sonev's operations on the site, nothing of note occurred until November of 2022, when Sonev began removing its mining equipment from the site. On an inspection visit done on July 26, 2023, the division staff noted that there was no equipment left on site and that the operator did not appear to be actively engaged in mining. The next inspection of the site was performed on October 30th, 2024. On that visit, not much had changed and the operator had ceased removing material. Both the BLM and the division agreed that the site should be reclaimed by the end of the year. About a year later, in October 2025, the division once again inspected the site, reaffirmed that the mine had gone inactive, and once again recommended a full reclamation. On the inspection done April 29th of this year, division staff noted that some reclamation work had been done, but that the work didn't meet the BLM standards for a full reclamation. Sonev also owed some unpaid permit fees. Based on those two facts, the division prepared to seek forfeiture of the bond if the BLM requested it. On May 6th of this year, the BLM sent a notice of noncompliance and a request for production payment to Mr. Gilbert. We've included a few excerpts from that on the next slide. The BLM and Sonev had a sales contract allowing Sonev to mine, and as of May 6th, only $7,223 of the total $21,000 owed to the BLM under that contract had been paid. The BLM informed Mr. Gilbert that if the remaining balance was not paid within 30 days, It would seek forfeiture of both the surety and the performance bond. The most recent inspection of the site was done on June 9th of this year. Mr. Gilbert and a representative of the BLM both accompanied the division on that visit, and the BLM came to the conclusion that the site had not been reclaimed to the extent the BLM requires. As such, the BLM requested that the division proceed with forfeiture. The applicable law here that supports the request for bond forfeiture is Utah Code Section 4814, subsection 6A. That provision states that if the operator of a mining operation fails or refuses to carry out the necessary land reclamation as outlined in the approved notice of intention, the board may declare any surety filed for this purpose forfeited. Under the administrative rules, the law also allows the board to forfeit a surety if the board makes a finding that an operator has violated the Mine Land Reclamation Act, which is Utah Code 40-8, a division order, or other administrative rules. Based on the evidence and the existing law, the division would request that the board issue an order that this operator failed or refused to complete reclamation, order that the $15,700 reclamation surety be forfeited to the division, that the division then use that money to complete reclamation according to the BLM standards, and in the event that there's any additional money needed to complete reclamation, that the division be allowed through the Assistant Attorney General to seek civil penalties and reclamation costs in a district court. If the board has any questions at this time, we'd be happy to address them.
Go ahead.
Quick question. Does the BLM have they filed any kind of, excuse me, I'm having trouble talking. Has the BLM issued any kind of requirements where they also have a bond, or is it just solely the bond is with the state?
I'll refer to you, Mr. Reyna, for that question.
There's several options here. We can either, the state can take possession of the bond and complete the reclamation, or we can actually issue the $15,700 to the BLM on top of the BLM's performance bond of $2,100, and the BLM would complete the reclamation.
So BLM has some recourse as well. Do they have anything from the abandoned mine land program as well that they can utilize any resources from that?
I'm not sure. In general, they do have a general fund that would be able to help facilitate reclamation.
Okay, Mr. Church? No, got it? Okay, okay.
So in this case, you know, it's a low dollar value, and it looks like the bond's going to cover it. But I'm curious why the state is bonding something on BLM ground. But why isn't it to BLM?
This is it is in fact of the BLM. It's under a 3809 contract that the state holds the reclamation surety. We just hold the bond for both the BLM and us ourselves.
Let me ask a different way, because maybe I still don't understand. Why is the state involved on a BLM, BLM ground activity?
I guess the easiest way to answer that is we, in conjunction, it is a state requirement also for the operator to have a mining permit with the Division of Oil, Gas, and Mining, and in conjunction with the BLM. Excuse me, I said a 3809 contract before. It's a 3600, either a sellable or leasable contract that they enter. So they have a plan of operations or a notice of intent under 5 acres that the BLM requires a separate notice of intent on theirs, but the state also requires a permit with the Division of Oil, Gas, and Mining.
So, sorry, more questions. So in this type of case, so as far as who has primacy as far as regulating this type of activity on BLM ground?
Do we have, is it just the two?
No, there's a
Essentially, it would be the BLM since they are both the surface and mineral
she didn't.
ownership.
Yeah.
Okay.
So along with that line of thinking, let's just assume that the reclamation was above and beyond the bonding figure. Who would be paying the difference? Would it be BLM? Would it be the state's responsibility? And even though it's on BLM land?
I'm not sure if I have the ability to answer that question. Under our bonding, we go through escalations to ensure that we have sufficient bonding.
Ms. Sierra, I don't know between BLM and the state who takes first dollar, but part of the request today before the board is that if there's any deficiency, that the division has the right to seek recovery of that from the corporation and Mr. Gilbert.
Other board questions? Okay. Let me ask a procedural question here. So none of the, okay, we all have received the exhibits electronically. Are you going to offer those as evidence? Are you going to ask? Okay.
Yes, we'd like to move to have those admitted as evidence.
Which ones?
All of them.
Can you identify them? Because we didn't see them all, did we?
They're just submitted for the board's reference and preparation, but they support all the testimony and presentation today.
Okay. Okay, so you're offering exhibits 1 through 12
That's correct.
as evidence? Okay, and, all right, so we'll admit those as evidence. The board all had an opportunity to review those. Okay.
The division's position on this matter is that the facts, the evidence presented, and the applicable law all show that this operator has failed to reclaim the site, and we would therefore ask for an order declaring that reclamation was not completed, that the $15,700 bond be forfeited to the division, and we would request in that order that the division be allowed to complete reclamation of the Desert Mound Waste Removal Project in coordination with the BLM.
Okay, all right. And again, no opposing comments by anybody? Okay. So, board, anything further before we, okay. So we could entertain a motion here?
I move that we approve the request for agency action to forfeit the bonding and turn it over to the division.
Okay. So, motion's been made and seconded to approve the request for agency action and turn the money over to, did you say division, but BLM?
Mr. Rainick can speak more to the actual process on that, but the division will coordinate with BLM on the reclamation.
Okay. All right. All right. All those in favor say aye.
Aye. Aye.
Any opposed say nay. Do we have anybody abstaining? Okay. The motion's been made and seconded and unanimously approved by the board. Welcome, Ms. Lipton, and I'm glad to have you on board. All right.
And she'll need a draft in order.
Yes, and so, again, we'll need a draft order before August 1st, so that I can get that signed before too long, all right?
Yes, we can do that.
Okay. With that, the board will adjourn until 10:30. Is that okay, Mr. McDonald? Okay. And how much time do you think you're going to need, Mr. McDonald? Okay. All right. So we are off the record.
Thank you.
Good morning, everyone. The board is back on the record, and we're going to start with agenda number 4, which is docket number 2026-035, cause number 130-52. In the matter of a request for agency action of 4 Point Resources LLC for an order 1, modifying the board's order in cause number 139-150 to reorient the drilling units established thereunder, comprised of sections 3 and 10 and 4 and 9 respectively, Township 4 South, Range 3 West, USM, from stand-up to lay-down, and to reduce the heel-toe setback with certain caveats related to existing wells thereon. 2, establishing overlapping lay-down 1,920 acre or substantially equivalent drilling units for extra long lateral horizontal wells for production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of section 3 through 5 and 8 through 10, Township 4 South, Range West, USM, respectively, and Section 6, Township 4 South, Range 3 West, USM, and Section 1 and 2, Township 4 South, Range 4 West, USM, and Section 7, Township 4 South, Range 3 West, USM, and Section 11 and 12, Township 4 South, Range 4 West, USM, respectively, and 3, establishing overlapping 3,840 acre or substantially equivalent drilling unit boundary well drilling units for extra long lateral horizontal wells for similar production along the common boundaries of said 1,920 acre drilling units, and comprised of Section 31, Township 3 South, Range 3 West, USM, Section 35 and 36, Township 3 South, Range 4 West, USM, Section 6, Township 4 South, Range 3 West, USM, and Section 1 and 2, Township 4 South, Range 4 West, USM, all in Duchesne County, Utah, with certain caveats related to existing well thereon. Sorry, Mr. McDonald, I used up 20 minutes of your 40 minutes just reading it. Okay, so let's take appearance for counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner 4 Point Resources.
Okay, thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. All right. Go ahead, Mr. McDonald.
Thank you, Mr. Chairman. With me appearing virtually pursuant to the board's July 13th order are Mr. Clint Cook, the senior landman, Ms. Sarah Smaltz, geologic planning manager, and Mr. Brett Kovach, senior reservoir engineer, and I would ask that the vice chair swear them in at this time.
Please raise your right arm to the square. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Okay.
All right, Mr. Chairman and members of the board, the resumes of all 3 witnesses were collectively submitted as Exhibit A. If separately asked, each would verify the contents contained therein are true and correct. Mr. Cook will be a fact witness only. Ms. Smaltz and Mr. Kovach have previously been recognized by the board as experts in geology and petroleum engineering, respectively. Presuming the division has no objections, we request that they again be so recognized in those disciplines for purposes of this cause.
Division?
No objections.
Board, any questions on the witnesses? No questions. Go ahead.
And as been standard practice, I will be moving for admission of my exhibits at the end of our presentation in chief.
Oh, one quick thing. So I need to disclose that my family has mineral interest in this request area. So I would like to participate in the hearing, but would recuse from voting.
No objection on our part.
Yeah, no objection from the division.
Members of the board, 4 Point is before you today seeking approval of a 3-part request. First, 4 Point is seeking modification of the 139-150 order to reorient the existing 2 sectional stand-up drilling units comprised of sections 3 and 10 and 4 and 9 respectively, established to a lay-down orientation. In other words, to change the drilling unit to sections 3 and 4 and sections 9 and 10 respectively, and also to reduce the heel-toe setbacks from 330 feet to 100 feet. At the time the 139-150 order was entered, Newfield, which was Four Point's predecessor, believed a stand-up orientation was appropriate. However, as the board is aware, in this portion of the Central Basin, the fracture orientation is transitional. Data developed from drilling after the 139-150 order was entered instead suggests a laydown orientation will result in more prolific production. Nevertheless, two 10,000-foot wells, horizontal wells, were drilled pursuant to the 139-150 order on the stand-up drilling unit basis, one in each of those two drilling units. Pursuant to the 139-150 order, production allocation from an existing vertical well within Section 4 converted to the Section 4 and 9 drilling unit basis. To avoid disruption of existing rights to production from that existing well and those two horizontal wells, Four Point is requesting that they remain on the existing production allocation under the 139-150 order, but providing that there will be no interwell setbacks between newly drilled laydown 10,000-foot wells and these existing wells. The board has previously recognized the need for such caveats in other drilling unit or reorientation orders in this general area. Second, Four Point is seeking establishment of 4 overlapping 3-sectional laydown drilling units for 15,000-foot horizontal well development of the Lower Green River Wasatch formations, comprised of sections 3 through 5 and 8 through 10, respectively, of 4 South, 3 West, section 6 of 4 South, 3 West, and sections 1 and 2 of 4 South, 4 West, and finally section 7 of 4 South, 3 West, and sections 11 and 12 of 4 South, 4 West. Sections 5 and 6, sections 7 and 8, sections 1 and 2, and sections 11 and 12 all were previously established as laydown drilling units pursuant to the 130-07 order. Pursuant to that order, 4 10,000-foot wells were drilled, one on each of the drilling units. Pursuant to the 130-07 order, production allocation from 2 existing vertical wells and 1 existing 5,000-foot short lateral horizontal well located in Section 6, Section 2, and Section 11, respectively, similarly converted to the respective 2-sectional drilling unit basis. The 137-07 order was subsequently modified by the 130-43 order to reduce the heel-toe setbacks to 100 feet. As the board is aware, the trend in the Uintah Basin is now to drill 15,000-foot or even longer wells. Four Point desires the 15,000-foot well development on these particular lands instead with a laydown orientation and with authorization to drill up to an aggregate of 17,000 10,000-foot and 15,000-foot wells, and with 100-foot heel-toe and 560-foot perpendicular setbacks. Again, however, it does not desire to disrupt existing rights to production currently established under the 139-150 and 130-070 orders, and therefore seeks that the requested drilling units overlap and not result in any additional conversion. Even though these will be overlapping drilling units, Four Point is requesting no interwell setbacks between the existing wells and the newly drilled 15,000-foot wells. As the board is aware, this is what the board has adopted in other matters recently, most recently in the 130-47 order, recognizing that the elimination of the interwell setbacks does not adversely impact adjacent existing wells. The last request deals with Four Point requesting establishment of overlapping drilling unit boundary wells along the common boundaries of these 3 sectional drilling units, and also with the drilling unit that's already been established to the north, with similar caveats as the board has previously adopted and outlined in more detail in the request. The drilling unit to the north is comprised of sections 31, 35, and 36, which were already established as a laydown drilling unit for 15,000-foot wells pursuant to the board's 130-37 order. True and correct copies of the 139-150, 130-07, 130-37, 130-43, and 130-47 orders were collectively submitted as Exhibit B in this cause. Since Indian mineral lands are involved, new communitization agreements are required, and the agencies, whether under federal guidelines or by practice, require a spacing order from the board for such communitization agreements to be approved. This is another reason why Four Point is before you today. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the requested reoriented and newly requested 3-sectional and drilling unit boundary well drilling units. The working interest owners, including unleased owners, in the adjacent drilling unit comprised of sections 2 and 11 of 4 South, 3 West, due to the reorientation and the requested boundary setback, and also to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and the Bureau of Land Management due to the Indian ownership, and also to the Utah School and Institutional Trust Lands Administration due to state ownership within these drilling units. The mailings were sent to these parties at their last addresses disclosed by the relevant BIA, SITLA, and Duchesne County Realty records. In addition, the notice of the filing of the request in this hearing was also duly published in the Uintah Basin Standard on July 1st and in the Salt Lake Tribune on July 5th. On July 8th, the division filed a response generally expressing no opposition to the granting of the request, presuming 4 Point meets its burden of proof today, which we will do. No other objections or responses to the request were timely filed, and no other party has made an appearance here today. With that, I'll commence my examination of Mr. Cook. Mr. Cook, would you please state your name and business address for the record?
Yes, Clint Cook, 4 Point Resources LLC, 100 St. Paul Street, Suite 400, Denver, Colorado, 80206.
And what is your current position with 4 Point, and how does it relate to the lands at issue today?
I'm a senior landman overseeing the DSUs at issue.
All right, would you please state for the record the corporate and bonding status of 4 Point?
Sure. 4 Point is Delaware Limited Liability Company with its principal place of address in Denver, Colorado. It is the successor by assignment to Ovintiv USA Inc., successor by name change and merger to Newfield Production Company. 4 Point is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all the state of Utah agencies.
All right, I'm going to show you what have been marked. Hopefully you have the PowerPoint in front of you of exhibits C through H. Do you recognize these exhibits?
I do.
Were they prepared by you or 4 Point personnel with your review and input?
Yes, they were.
Starting with exhibit C, would you please explain what this shows?
Sure, this is a regional locator plat showing the DSUs at issue here today, located approximately 5 miles due east of Duchesne and bisected by a US 40.
Right, now turning your attention to exhibit D, this is a 3-page exhibit. Starting with the page exhibit D1, would you please explain what this shows?
Yes, this reflects the DSUs as they currently exist under orders 139-150, 130-07, and 130-37 orders.
And the section 3, 4, 9, and 10 are currently stand-up drilling units, that's correct?
Correct.
All right, turning your attention now to exhibit D2, please explain what this shows.
Yes, this reflects the requested reoriented DSUs with the 2-sectional DSUs shown in blue and the new overlapping 3-sectional DSUs in the red dash.
And finally, turning to exhibit D3, please explain what this shows.
Yes, this reflects the overlapping drilling unit boundary well DSUs as requested.
Now turning your attention to exhibit E, please explain what this shows.
This is just a mineral ownership type plat showing the Indian minerals in green, fee minerals in yellow, and SITLA state minerals in blue.
And what has been your experience with dealing with the federal agencies and trying to get communization agreements approved that include Indian lands?
Yeah, based on our experience, when Indian minerals are involved, a spacing order not only facilitates but is required by the BLM and or the BIA for approval of conforming communitization agreements, whether by guidelines or their actual agency practice.
Now turning your attention to exhibit F, please explain what this shows and its significance to today's hearing.
Exhibit F shows 4 Point's working interest in each of the DSUs, demonstrating a clear majority interest in each of them, and thus a majority interest in the newly requested DSUs.
And just for clarification, when it has the column partner, this is a situation where the partner has designated 4 Point as the operator to operate on their behalf. Is that correct?
Correct, where they've historically been a participating working interest partner in the existing wells.
Now, turning your attention to Exhibit G, would you please explain what this shows, and in particular the significance with request to some of the exemptions that 4 Point is requesting?
Yes, Exhibit G displays the existing wells in the DSUs. So you can see the two 10K north-south wells in the blue boxes that will remain in the stand-up orientation.
And
as
the,
well as,
yeah, go
sorry.
ahead. Go ahead. I'm sorry.
Okay. Also existing vertical and 5K well production allocation has been previously converted per the 139-150 order and the 130-07 order to the two sectional DSU basis.
All right, now turning your attention to Exhibit H, which relates to those existing wells, please explain what this shows.
This is a table of production allocation for the existing wells, just demonstrating that each of those will remain on their existing allocation schedules.
So there won't be any interruption in their existing production allocation if the request is granted?
Correct.
Okay, finally, turning your attention to Exhibit I, would you please explain what this shows?
This is the notice area for the RAA, showing that all owners of a production interest within the red area were noticed, as well as an offset notice area to all working interest owners in sections 2 and 11 on the east side, due to the reorientation of those DSUs and the request for 100-foot setbacks on that end.
Okay, now I'm going to ask you to refer to the certificates of service and the supplemental certificate of service. You should have hard copies in front of you of those. Those are pleadings prepared by our office on file in this matter. Do you recognize the names and addresses shown on that?
Yes.
And who are those parties and how are those names and addresses compiled?
Those are parties owning production interest in the subject lands and working interest in the adjacent DSUs as reflected on Exhibit I. It also includes government agencies having mineral jurisdiction. These include BIA, BLM, Vernal Field Office, and SITLA.
And how are those names and addresses compiled?
So those parties were compiled from 4 Point's internal land records, including title opinions in a search of the BIA, SITLA, and Duchesne County records prior to the filing of the RAA. And this work was conducted by Lone Wolf Energy, Inc., who is 4 Point's contracted land services company.
All right, and for the board's reference, again, because this was just regular mail, there's no Exhibit Z reflecting return receipts. With that, that concludes my examination of Mr. Cook.
Division?
Thank you. Just a couple questions, Mr. Cook. Could we please look at Exhibit G? So I noticed the JMD well is there. The JMD well is currently being paid on section 4 and 9 on the stand-up unit. I was just curious, was there any thought to having it also convert with these new laydowns, or what was the thought process there to keep it as stand-up?
So the JMD well, are you the
in section
vertical
4?
It's currently being P&A'd right now.
Oh, okay.
Yep.
Well, that. Then
My neighbor.
okay.
Well, I have a very unhappy landowner that has that on them, so I hear about it.
Okay, well, let's move on from that one. Just a quick question, Exhibit E. This is just for my curiosity. What is the white horseshoe shape on the left-hand side of the map? I'm just curious what that is.
Oh, so that's where the river cuts through. We should have technically colored that green. I think that's a function in our mapping system, but
So
where
that's still Indian mineral ownership?
correct,
Okay.
because in that instance, you have allotted Indian minerals on both sides of the river. So those adjacent tracts will each own to the center of the river on their respective sites.
All right, thank you. No more questions for Mr. Cook from the division.
Board, do you have any questions of Mr. Cook?
Yes.
Go ahead.
Mr. Cook, the drilling boundary unit, you're looking for 3,840 acres, is a very large unit for a well. So will that just be one boundary unit well that will have 6 sections mineral owners participating in?
It could potentially be more than one well, is in the sense that you could have one drilled to different formations along that lease boundary.
Okay, so in that sense, vertically, you could see vertically section-wise, horizontal layers, there could be a few wells in that large of a unit.
Potentially like you could have a Uteland Butte well as well as a Wasatch well or something along that boundary line.
Okay, thank you.
Again, Mr. Church, the caveats are that they have to drill on both so that there's production holding it before you have the drilling unit boundary well. There wouldn't be a drilling unit boundary well alone holding all 6 sections.
Correct.
Okay.
Board, other questions? Go ahead, Mr. Mayor.
Yeah, Exhibit E again. Just out of curiosity, so my house is right under one of those blue state sections. How did the state, do you know how the state ended up with the mineral, those random 80-acre plots? Is that clear back from patent, or do you know?
I don't know the history of them. I'd have to do some research there. But I did, confirm that the state lands on that. But I'm sorry, I don't know the history of how those came about.
Okay, thank you.
Yes.
Board, other questions, Mr. Cook? Okay, proceed, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination. Ms. Schmaltz. Ms. Schmaltz, would you please state your name and business address for the record?
Yes, Sarah Schmaltz, 4 Point Resources LLC, 100 St. Paul Street, Suite 400, Denver, Colorado, 80206.
And what is your current position with 4 Point, and how does it relate to these lands?
Yes, I'm the geologic planning manager overseeing long-term development, including the DSUs I issued today.
All right, I'm going to turn your attention to Exhibits J through M. For purposes of this hearing, do you recognize these exhibits, and were they prepared by you or 4 Point personnel with your review and input?
Yes.
All right, turning your attention to Exhibit J, would you please explain what this shows and its significance to today's hearing?
Yes, on Exhibit J, the map is highlighting the location of the proposed DSUs in relation to the field type log, the Shell Brotherson 1-11B4, which has been used and recognized in numerous orders, including the 139-150, 130-07, and 130-37 orders. On the left-hand side, you'll see that the stratigraphic interval, which is defined as the lower Green River to Wasatch transitional formations, is highlighted on the type log.
Now turning your attention to Exhibit K. Again, please explain what this shows and its significance to today's hearing.
Yes, Exhibit K is displaying a type log that's located directly within the center of the area issued today. This is the Moon 13-6-4-3W. It is highlighting the primary target intervals for the area and for the 15,000-foot wells that may be proposed in the subject DSUs.
Now turning your attention to Exhibit L. Again, please explain what this shows and its significance.
Yes, Exhibit L is a west to east stratigraphic cross-section through the DSUs at issue, including the local type log that was on the previous exhibit. This cross-section is reflecting the uniformity of the primary target intervals, which makes these units conducive to 15K development. This is also highlighting that the lower Green River to Wasatch transitional formations constitute one common source of supply in this area and is consistent with the board's designation of those formations as one pool throughout the Uintah Basin.
And to Exhibit M, please explain what this shows and its significance to today's hearing.
Exhibit M is displaying the interpreted maximum stress direction in the areas surrounding the DSUs that we're talking about today. Wells with observed stress indicators are shown with the black arrows. The average maximum stress direction at the proposed DSUs being reoriented to laydown units, which are shown in the dashed blue boxes, is interpreted to be north 31 degrees west. This supports laydown drilling units rather than the prior stand-up orientation. Also shown on this exhibit, highlighted with the red star, is a nearby well, the Alice 13-7-4-3-18-19-7H, for which the PVT data was used for drainage calculations, and Mr. Kovach will address these data in the following exhibits.
All right, is it your expert opinion then that the uniformity and thickness make the lower Green River Wasatch an attractive target for 15,000-foot well drilling?
Yes.
Is it also your expert opinion that the fracture orientation supports a laydown drilling unit orientation?
Yes, sir.
And finally, is it your expert opinion that the lower Green River Wasatch constitutes one common source of supply in this area?
Yes.
With that, Mr. Chairman, that concludes my examination of Ms. Schmaltz.
Okay. Division?
The division has no questions for this witness. Thank you.
Board, any questions of Ms. Schmaltz? Okay, seeing none, go ahead and proceed, Mr.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Kovach. Mr. Kovach, would you please state your name and business address for the record?
Yes, it's Brett Kovach and 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what is your current position with 4 Point, and how does it relate to these lands?
Yes, I'm the senior reservoir engineer overseeing the DSUs at issue.
Okay, turning your attention to what have been marked as exhibits N, O, P, and Q. Do you recognize these exhibits, and were they prepared by you or 4 Point personnel with your review and input?
Yes, they were.
All right, turning your attention to Exhibit M, would you please explain what this shows?
Yeah, so the main takeaways from Exhibit N are showing the orientation of the North 31 West fracture azimuth, and that our effective fracture half lengths are expected to be no more than 110 feet. We can also see here that the requested setback of 100 feet will prevent waste and maximize the natural resource recovery, and the correlative rights will not be adversely affected.
Now, turning your attention to Exhibit O, would you please explain what this shows?
Yes, Exhibit O presents the drainage calculations using the Hale and Evers methodology, which we've shown before and the division and board have previously accepted. As Sarah showed earlier in Exhibit M, the PVT parameters used in this analysis are coming from the Alice 13-7-4-3-18-19-7H, which is a Uteland Butte well in sections 18 and 19 of Township 4 South and Range 3 West. And we can also see from these calculations that they demonstrate that there is no drainage of adjacent lands at 5 years and only minimal, if any, drainage at 10 years and beyond.
Turning your attention to Exhibit P, please explain what this shows and its significance to today's hearing.
Yes, so Exhibit P is similar to what we've shown in the 130-47 hearing. And what we can see here in both cases that we're showing here, the Stanley DSU and the Blackhair DSUs, is that really when you tend to drill by these kind of cross these old well bores with a modern well, you generally actually end up seeing an uplift in production from to the original wells that were drilled there.
All right, and can you confirm that the testimony that you gave and the board's findings in the 13047 order regarding the elimination of interwell setbacks is still the case?
Yes.
All right. Can you address what steps are taken to protect the existing wells during drilling and completion of a new 10,000 or 15,000 foot well?
Yeah, so during this process, we do take deliberate steps to ensure that the existing wells are protected. So, prior to drilling, our team conducts a detailed anti-collision analysis so that we're really understanding kind of what the cone of uncertainty is and try to ensure there's no collisions. During the completion process, we sometimes shut in the existing wells to allow for pressure to build, and then we of course closely monitor the pressures throughout the operation to reduce incremental risk there at all. And then periodically, we may skip stages around the existing well bores to avoid direct hits.
Now turning your attention to Exhibit Q, please explain what this shows.
Yes, so Exhibit Q is an economic comparison of the 10K versus the 15K lateral length wells. So we can really see here in Exhibit Q is that it outlines the economic benefits of extending laterals, and these are consistent with what we see in other basins. So shown here is an estimate that the cost per foot is reduced by roughly 15% when going from a 10K to a 15K, while the per foot productivity remains essentially unchanged. The result from this is, of course, more resource recovered per dollar of capital invested, which means that this economics strongly favor the 15,000 foot development.
But there are circumstances where it would still be necessary to drill a 10,000 foot well to recover the resources, or depending on the circumstances of the reservoir characteristics. Is that correct?
Yes, that's correct.
All right. You've requested that there be 17 aggregate 10,000 and 15,000 foot wells. Can you kind of address where you came up with that number?
Yes, so that's, looking at the stack of rock that we have here in the Uintah Basin and kind of going through our different spacing assumptions and ensuring that, we have enough wells there in each bench to make sure that we drain effectively the resource available.
All right. Can you briefly address, although I'm sure the board is well aware, the need for the drilling unit boundary well that you're requesting?
Yeah, so, if we kind of look back at some of the prior exhibits and evaluate the fracture half lengths there, you can see that really those, the drilling unit boundary well area would not be recovered efficiently if we were not to drill an incremental well into that area.
All right. Is it your expert opinion then that up to 17 aggregate 10,000 and 15,000 foot wells may be required to recover additional resources in each of the requested drilling units, which would otherwise be left in the ground?
Yes.
Is it also your expert opinion that 100-foot heel toe and 560-foot perpendicular setbacks will not adversely affect the correlative rights of adjacent parties?
Yes.
Is it also your expert opinion that 15,000-foot wells appear more economic than 10,000-foot wells?
Yes.
Is it also your expert opinion that drilling unit boundary wells are needed to recover resources between adjacent drilling units?
Yes.
Finally, is it your expert opinion that elimination of the interwell setbacks between existing wells and newly drilled 10,000 and 15,000 foot wells in general benefits rather than harms the correlative rights of the owners in those existing wells and is consistent with practices in other basins, including the Uintah Basin?
Yes.
With that, Mr. Chairman, that concludes my examination. Mr. Kovach.
Okay. Division.
Division has no questions for this witness. Thank you.
Okay, board, do you have any questions of Mr. Kovach? No, don't see any questions, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of exhibits A through Q inclusive.
Okay, admitted.
Thank you. With that, I'll reserve just a few closing remarks after the division makes its statement.
Okay, go ahead.
Thank you. As indicated, the division filed a notice of no opposition for this RAA. After reviewing the RAA and the exhibits and listening to the testimony here today, the division is satisfied with the request and continues to have no opposition to granting of this request. Thank you.
Great, thank you. Board, any questions of Mr. Haynes or comments? Okay, go ahead and wrap up, Mr. McDonald.
Thank you, Mr. Chairman. Again, we believe that all the statutory and regulatory requirements for granting 4 points requests have been satisfied. This will satisfy the board's charge to maximize resources without waste and protection of correlative rights. I'd particularly like to thank the board and the IT people for the allowance of the witnesses to appear virtually, and we would ask that the board approve the request as submitted.
Okay, thank you. Okay, board, any need to deliberate? Not seeing any need to deliberate. Anyone care to make a motion?
I move that we approve the request for agency action.
Okay.
I'll second.
Okay, it's been moved and seconded that board approves the request for agency action by 4 points. All those in favor say aye.
Aye.
Any opposed say nay. Any abstain?
Yep.
Oh, yes, and one abstention. Thank you. Okay, so it's unanimous with one abstention that the request for agency action is completed. Again, I am leaving on August 1st or 2nd, so if you want that order soon, please.
Right,
get it
we'll
forward.
get it in time.
Okay, thank you.
All right, thank you.
Are there any other matters that need to appear before the board before we adjourn? Okay, I entertain a motion to adjourn.
I move that we adjourn this meeting.
Okay, second. All in favor, say aye. Aye. Opposed? Okay. This meeting is adjourned. We're off the record. Thank you.